Everyone knew him as Star-Lord from Guardians of the Galaxy. But when Chris Pratt stood up in federal court that day, he was about to reveal a secret he had kept hidden throughout his Hollywood career. Not just action hero charisma, but deep environmental law expertise, years of studying corporate responsibility and constitutional environmental protections, mastery of regulatory compliance frameworks. Judge Edward Chen was dismissing him as just another actor playing environmentalist, unaware that standing before him was someone who understood environmental law better than most corporate attorneys. Pratt's first legal argument alone would completely transform the courtroom atmosphere. "Your Honor, Judge Chen," said Pratt, his voice carrying the same earnestness that had made him beloved by millions, "may I speak to you about the Commerce Clause's relationship to environmental regulation and the constitutional limits on corporate environmental liability?" What happened that day in the San Francisco federal courthouse would revolutionize both environmental law and our understanding of constitutional corporate responsibility. Before diving into this extraordinary fictional legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected legal brilliance challenging established authority. Chen's world, business-friendly. Judicial authority. Judge Edward Chen represented the corporate-friendly federal judiciary. At 61, the federal judge had built his reputation on business-oriented rulings and skepticism toward expansive environmental regulations that burdened corporate defendants. A Harvard Law graduate with extensive experience in corporate litigation, Chen embodied traditional judicial approaches favoring business interests over environmental claims. His judicial philosophy emphasized economic growth and limited regulatory interference with corporate operations. Chen particularly questioned whether environmental activists understood the economic complexities of regulatory compliance and corporate responsibility. That day, his assumptions about Chris Pratt were predictable. Yes, Pratt was successful in Hollywood. Yes, he had expressed environmental concerns publicly, but in Chen's view, he was simply another celebrity using legal theatrics to promote environmental activism, rather than a serious advocate for constitutional environmental law. This assessment would prove to be a significant miscalculation. Pratt's hidden journey. From parks to environmental law. The world knew Chris Pratt through his entertainment evolution and cultural impact. From Andy Dwyer on Parks and Recreation to Star-Lord in the Marvel Cinematic Universe, his journey from comedian to action star had made him one of Hollywood's most beloved figures. With blockbuster success and a platform reaching millions, Pratt had become a significant cultural influence. But what the public didn't know was that Pratt's love for the outdoors and environmental awareness had sparked intensive study of the legal frameworks governing environmental protection and corporate responsibility. Starting in 2014, inspired by his outdoor experiences and growing environmental consciousness, Pratt had begun serious study of environmental law and constitutional regulatory principles. "I spend so much time in nature for filming and personal enjoyment," he had confided to his wife Catherine during one of their hiking trips. "I realized I need to understand the legal system that either protects or fails to protect the environment we all depend on." Working with environmental law professors from Stanford and UC Berkeley, Pratt spent his time between film projects studying Supreme Court environmental precedents, regulatory law, and the constitutional foundations of environmental protection. He completed advanced coursework in environmental law, constitutional interpretation, and the intersection of corporate responsibility with constitutional governance. By 2023, when the case that would bring him to federal court emerged, Pratt wasn't just advocating for environmental awareness, he was also a well-educated advocate for constitutional environmental protection with genuine expertise in the environmental law that governed corporate responsibility and regulatory enforcement. The Case Foundation. Environmental protection versus corporate rights. The federal case that brought Chris Pratt before Judge Chen represented one of the most significant environmental law challenges in recent history. Pratt v. Meridian Industries challenged a major corporation's environmental practices as violations of both federal environmental statutes and constitutional due process principles. The case had emerged when Pratt filed a comprehensive environmental lawsuit claiming that Meridian Industries' manufacturing processes violated Clean Air Act standards and created public health hazards that the company had systematically concealed. He argued that corporate environmental violations constituted both regulatory violations and constitutional deprivations of public health rights. The implications extended far beyond Pratt's situation. If his legal theory prevailed, it would establish new constitutional frameworks for environmental protection and corporate accountability. If Meridian won, it would confirm that corporate environmental practices received broad protection from environmental litigation. For Chen, this case represented an opportunity to defend legitimate business operations while maintaining regulatory balance. He viewed it as a matter of preventing environmental activism from disrupting established corporate practices. For Pratt, the case was about fundamental constitutional principles, whether corporations could constitutionally harm public health through environmental violations, and whether the government had constitutional obligations to protect environmental public health. The setting: San Francisco Federal District Court. The modern courtroom of the U.S. District Court for the Northern District of California was packed with environmental lawyers, corporate defense attorneys, and environmental advocacy organizations. This case had drawn national attention both because of Pratt's celebrity status and its potential impact on environmental law and corporate responsibility. At the plaintiff's table sat Chris Pratt, dressed in a conservative navy suit that projected environmental seriousness rather than Hollywood glamour. His legal team from environmental law firms flanked him, though Pratt had insisted on presenting key constitutional arguments himself, a decision that had surprised environmental law experts. At the defense table, Meridian Industries had assembled their most experienced corporate defense attorneys, led by General Counsel Robert Martinez, a Stanford law graduate with decades of experience in environmental litigation. Behind them sat corporate executives and industry representatives, all confident this would establish important precedents protecting corporate environmental practices. Judge Chen, presiding over this case due to its significance for environmental regulation, had already made his business-friendly approach clear through his previous environmental law rulings. First contact: the dismissive challenge. Mr. Pratt, Judge Chen began, his voice carrying the authority of federal corporate jurisprudence, this court recognizes your entertainment success in environmental advocacy. However, environmental law involves complex regulatory frameworks and sophisticated corporate compliance issues. Are you prepared to engage seriously with established environmental doctrine rather than asserting emotional appeals about environmental protection? The question was designed to highlight what Chen saw as the fundamental difference between celebrity activism and legal expertise. His tone suggested he expected Pratt to rely on his legal team or demonstrate the kind of regulatory superficiality he associated with celebrity environmental litigation. Pratt stood deliberately, his posture respectful but confident. Your Honor, I understand your concern about regulatory complexity. However, I'd like to address that concern by discussing the Supreme Court's analysis in Massachusetts versus EPA and how environmental protection serves constitutional purposes beyond regulatory compliance. A surprised murmur went through the courtroom. This wasn't the celebrity environmental activism Chen had expected. The Clean Air Act, Pratt continued, operates under congressional authority derived from the Commerce Clause, but its constitutional purpose extends beyond interstate commerce regulation. When corporations violate environmental standards, they violate both regulatory law and constitutional principles protecting public health and welfare. Chen's expression shifted slightly. The response demonstrated actual understanding of constitutional environmental law, not just environmental advocacy talking points. Testing the constitutional waters. Mr. Pratt, Chen continued, his tone becoming more serious, citing landmark environmental cases is one thing. Understanding how modern courts balance environmental protection against economic impacts and corporate rights is quite another. Are you familiar with how contemporary environmental law evaluates regulatory burdens on business operations? This was the kind of question designed to separate constitutional amateurs from serious environmental law practitioners. Pratt nodded confidently. Absolutely, Your Honor. The court's framework in Chevron USA Inc. v. Natural Resources Defense Council establishes that environmental agencies receive deference in interpreting environmental statutes, but this deference has constitutional limits when corporate activities violate fundamental public health protections. Chen leaned forward, his interest clearly piqued. Continue with your constitutional analysis. Meridian's environmental violations, Pratt proceeded, exceed the scope of legitimate business operations protected by constitutional due process. When corporations systematically conceal environmental harms that affect public health, they violate both regulatory standards and constitutional principles protecting community welfare. The courtroom had grown quiet. Environmental reporters were taking detailed notes, and even Meridian's attorneys were paying close attention to this unexpected constitutional discourse. The revelation. Pratt's environmental law expertise. Mr. Pratt, Chen said, his tone now markedly different from his initial dismissiveness, your constitutional analysis of environmental law demonstrates considerable legal sophistication. Where did you develop this expertise in environmental regulation and constitutional environmental principles? Pratt's response would reveal the depth of his legal preparation. Your Honor, I've spent nearly a decade studying environmental law and constitutional environmental protection, initially through Stanford Law's environmental program, later through private study with constitutional scholars specializing in environmental regulation and corporate responsibility. I've worked directly with Professor Deborah Sivas at Stanford on environmental constitutional theory, studied under Professor Richard Lazarus at Harvard on environmental statutory interpretation, and completed advanced coursework through UC Berkeley's environmental law program, focusing specifically on the intersection of corporate responsibility, environmental protection, and constitutional governance. The courtroom buzzed with surprise. Chen himself looked genuinely taken aback. Moreover, Pratt continued, my personal experience with outdoor environments and my platform as a public figure have given me unique insight into how environmental degradation affects communities and ecosystems. I've seen firsthand how corporate environmental violations harm the natural systems that sustain human life and economic activity. Chen's deeper constitutional challenge. Chen, now taking Pratt's argument seriously, decided to test the deepest level of his constitutional understanding. Mr. Pratt, your case essentially argues that corporate environmental violations constitute constitutional violations beyond regulatory non-compliance. But how do you address the legitimate economic interests that environmental regulation must balance against environmental protection? This question went to the heart of modern environmental law, the sophisticated balance between environmental protection and economic development that typically separated legal generalists from serious environmental practitioners. Pratt's answer would demonstrate whether he truly understood the complexities of constitutional law in the environmental context. Your Honor, there's a crucial distinction between legitimate economic activity, which the Constitution protects, and corporate environmental violations that harm public health, which exceed constitutional protection for economic activity. He paused to organize his constitutional argument. The Supreme Court's decision in Lucas v. South Carolina Coastal Council established that environmental regulations serve compelling governmental interests in protecting public health and safety. When corporations violate these protections, they forfeit constitutional protection for their economic activities. Chen was now fully engaged with Pratt's constitutional analysis. You're arguing that environmental violations remove corporate activities from constitutional economic protection. I'm arguing that when corporate activities systematically violate environmental laws designed to protect public health, those activities exceed the scope of constitutional due process protection for economic activity, Pratt responded. The Constitution protects legitimate business operations, not corporate environmental violations that harm community health. The precedent analysis, building environmental constitutional framework. Moreover, Pratt continued, we have direct precedent for limiting constitutional protection for harmful corporate activities. The Supreme Court's decision in Penn Central Transportation, Co. v. New York City, held that regulations serving important public purposes, including environmental protection, receive constitutional deference even when they burden corporate economic interests. Chen was taking careful notes. How does Penn Central apply to corporate environmental violations? Penn Central's constitutional principle applies directly to Meridian's environmental violations, Pratt replied. The court recognized that environmental protection serves fundamental governmental interests that justify regulatory restrictions on corporate activities. When corporations violate these protections, they cannot claim constitutional immunity from environmental enforcement. Pratt then presented his most sophisticated constitutional argument. The court's recent decision in County of Maui v. Hawaii Wildlife Fund confirms that environmental protection serves constitutional purposes that extend beyond narrow regulatory compliance. When applied to corporate responsibility, this means companies cannot use constitutional economic rights to shield environmental violations that harm public health. Chen's constitutional recognition. The change in Judge Chen was evident to everyone in the courtroom. His initial skepticism had evolved into genuine engagement with Pratt's constitutional arguments. Mr. Pratt, Chen said, I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented environmental arguments that merit serious consideration from this court. Thank you, Your Honor, Pratt responded. I hope this demonstrates that constitutional environmental protection serves fundamental governmental purposes that transcend traditional economic interests. Environmental law exists to protect the natural systems that make economic activity possible. Chen nodded thoughtfully. Your argument essentially contends that corporate environmental violations exceed constitutional protection for economic activity. This raises fundamental questions about the relationship between environmental protection and constitutional corporate rights. The Corporate Constitutional Defense General Counsel Martinez, representing Meridian, attempted to refocus the constitutional conversation. Your Honor, while Mr. Pratt's environmental studies are noteworthy, the fundamental issue remains economic certainty. Manufacturing operations require regulatory predictability to maintain operations and employment. Chen turned to Martinez with new interest in the constitutional balance. Counselor, how does Meridian respond to Mr. Pratt's argument that systematic environmental violations exceed constitutional protection for corporate economic activity? Martinez found herself defending corporate practices against sophisticated constitutional arguments rather than dismissing celebrity environmental activism. Your Honor, environmental regulations must balance environmental protection against economic impacts on business operations. Pratt was prepared for this constitutional response. Your Honor, Meridian's economic balance argument ignores the constitutional principle that legitimate economic activity must operate within legal bounds. In Hoddle v. Virginia, Surface Mining and Reclamation Association, this court held that environmental regulations serve compelling governmental interests that justify restrictions on economic activity when that activity harms public welfare. Constitutional framework development. Pratt then presented his proposed constitutional solution. I suggest a framework that protects both legitimate economic activity and constitutional environmental protection. First, corporate economic activities receive constitutional protection when they comply with environmental laws designed to protect public health. Second, systematic environmental violations forfeit constitutional protection because they exceed legitimate economic activity. Third, environmental enforcement must serve constitutional purposes of protecting public health rather than simply imposing regulatory burdens. Chen engaged directly with this constitutional framework. How would your framework address corporate concerns about regulatory uncertainty and compliance costs? The framework protects legitimate business operations while ensuring they serve constitutional purposes, Pratt responded. Rather than restricting all corporate activity, Environmental law distinguishes between legitimate business operations and corporate activities that violate public health protections. The Constitution requires this distinction because economic rights exist to serve human welfare, not to protect activities that harm community health. Pratt concluded with his strongest constitutional argument. Environmental protection serves constitutional purposes because healthy environments are necessary for the life, liberty, and pursuit of happiness that the Constitution protects. When corporations violate environmental laws, they undermine these fundamental constitutional values. Chen's final constitutional assessment. The hearing concluded. Judge Chen addressed Pratt directly. "Mr. Pratt, your constitutional arguments today have been remarkable. You've demonstrated understanding of environmental law and constitutional principles that rivals the most experienced environmental advocates." "Thank you, Your Honor. This case has never been about attacking legitimate business operations. It's been about ensuring that corporate activities serve constitutional purposes of protecting public health rather than undermining the environmental foundations that make economic activity possible." Chen reflected on the broader constitutional issues. "Your arguments raise fundamental questions about the relationship between economic activity and constitutional environmental protection. This court will examine them with the constitutional seriousness they deserve." The landmark environmental decision. 2 weeks later, Judge Chen issued a comprehensive 38-page decision that would reshape environmental law and constitutional corporate responsibility. The ruling found that systematic environmental violations exceeded constitutional protection for corporate economic activity and required enhanced environmental enforcement. More significantly, Chen's opinion adopted key elements of Pratt's constitutional framework, creating new precedent for how courts would evaluate corporate environmental responsibility against constitutional principles. The decision included an extraordinary judicial acknowledgment. This case demonstrates that constitutional environmental wisdom can emerge from those who understand both the practical importance of environmental protection and the legal frameworks that govern corporate responsibility. Mr. Pratt's analysis has contributed meaningfully to this court's understanding of constitutional environmental law. Broader constitutional and environmental impact. The Pratt vs. Meridian. Industry's decision created immediate changes in corporate environmental practices and sparked national conversation about constitutional environmental protection. Environmental law scholars praised the decision as a landmark victory for constitutional environmental rights. Law schools immediately began incorporating Pratt's constitutional arguments into their environmental law and constitutional law curricula. The case became required reading for environmental law, constitutional law, and corporate responsibility courses nationwide. For the business community, the decision established new precedents requiring corporate environmental compliance while preserving constitutional protection for legitimate business operations that respected environmental laws. Long-term constitutional legacy. The constitutional precedents established in Pratt vs. Meridian influenced environmental law for years afterward. The decision's framework for balancing corporate rights with environmental protection became a model for courts addressing environmental and constitutional law. Most importantly, the case demonstrated that constitutional expertise could emerge from environmental experience, and that the most meaningful environmental arguments often came from those who understood both environmental protection and constitutional principles. Chris Pratt had proven that true constitutional advocacy for environmental rights requires combining practical environmental understanding with rigorous legal scholarship, and that protecting environmental health demands the same constitutional courage that has always been necessary to defend fundamental rights. If you found this incredible fictional story of environmental constitutional courage and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise, challenging established authority. Ring that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge and environmental awareness can combine to protect our planet's future. What did you think of this fictional portrayal of Chris Pratt's constitutional expertise? Share your thoughts in the comments below.